Hello, everyone, and welcome to the weekly seminar of the Cyber Policy Center and the program on democracy and the internet. I'm Nate Persley. I'm co-director of those programs. And we're honored today to have with us Eric Goldman, who is a professor at Santa Clara University School of Law, as well as the Associate Dean for Research there, a board member of the Trust and Safety Professional Association, and all-around leader in the area of content moderation, First Amendment, et cetera. Eric's going to talk for about half an hour, and then we will have questions. So please put your questions into the Q&A, and I will launch them at him. I'll probably start with a few questions of my own, and then turn it over to the audience. Eric, you can now unmute your screen. Thanks for joining us today. We really look forward to hearing you talk about validating transparency reports.
All right, well, thank you. And I'm just so grateful for the opportunity to speak with this audience. And I'm really looking forward to hearing your thoughts about it. I worry that not everyone's going to like this paper. That's going to be great comments for me, but I'm not looking to trigger anyone, but I might end up doing so anyway. As usual with projects in process, the title has changed. Today, I'm using the title of The Constitutionality of Mandating Editorial Transparency. It's the same basic concept, but I'm restyling a little way to prioritize the constitutional piece. Now I'm going to work you through a deck here. So if you'll give me just a moment, I'm going to get the deck up on the screen, and then I'll walk you through it. Okay, very good. Let me start by talking about the role of transparency in the policy discourse. In general, when it comes to trying to control the behavior of publishers of third-party content online, I'm going to call them internet services. Many of you will call them platforms. There's a partisan gridlock today that's blocking the ability of the regulators to move forward. In general, the summary is that the left wants more content removed online. The right wants less content removed online. And so this partisan gridlock has really, I think, stymied any regulatory efforts in legislatures that aren't controlled with some kind of supermajority or have enough to power through despite partisan differences. But in those places where there's that gridlock, transparency has been offered as kind of the third way. It's not the red pill, it's not the blue pill, it might be like the green pill that people could take as a way to bypass the gridlock. Because everyone loves transparency. Who doesn't want to know more information about the world at large? We all have curiosity and interest in what's taking place. The more we can learn about that, in theory, the better our insights might be. And there's other benefits to it as well, things like the fact that what gets measured gets done, as we know from the management literature. If you're measuring things through transparency, you can control behavior. The idea is that by producing more information to the market, that the market might be able to better discipline actors by identifying where they're making poor judgments or creating problems, and then holding them accountable. So in general, everyone loves transparency. This is not just a hypothetical. We've seen now 2 states that have enacted transparency laws I'm going to focus on. There are other transparency laws that have been adopted at the state level, and depending on definition, even more broadly, but let me focus on the 2 that have been adopted in 2021. First, I'll mention Florida SB 7072 defines a thing called social media platforms with a very, very broad definition. Happy to talk about it if we want. And they require social media platforms to first post editorial standards. So this is disclose your rules in your terms of service. And then they require that internet services provide explanations for their editorial decisions. So to the extent that in certain circumstances, internet services make an adverse decision on a particular item of content, then they're required to provide an explanation. there's a lot more going on in SB 7072, but I'm just focusing on the transparency elements of it. Then a couple months later, after that, Texas enacted HB 20, which required everything that I mentioned from the Florida law. And then it went further. It required, and I have to quote this because I don't know how to summarize it. I don't know how to distill it. It requires that internet services, or they use the term social media platforms as well, publicly disclose accurate information regarding its content management, data management, and business practices. Now, there's some specific examples that are given of things that might qualify under this, but pretty much, I don't know what's excluded from this definition. It's really, really broad. And then on top of that, they actually demand biannual transparency reports. You know the kinds I'm talking about, where there's statistics about what the internet services did, how they handled particular topics, or what kinds of quantities of user responses there were. And so for those of you who are interested in transparency reports, you can look at the Texas law as one of the more inclusive ones. It really asks for pretty much everything you might expect. Okay, so these are some of the laws that we're seeing coming down the pipeline. And as you can probably already infer, I'm not a fan of these laws, but I'm gonna explain where these laws go wrong. And let me give you a preview or an outline of how I'm going to do that. So this is basically the steps in my my logic that lead to the conclusion that many of you aren't going to like. So the first step is that internet services make editorial decisions. Now, I'm happy to debate this with anyone if they want. I'm not going to spend more time on it in this talk, though I have a section about this in the paper where I'm going to blow out a more fulsome defense. But whenever we think about internet services, social media platforms, and the editorial operations that they're engaged in, what they're doing is they're publishing third-party content. That's not really in debate, in my opinion. We could certainly find other services that are doing other things, such as, say, even the Zoom call, we might have a different framing of it. But the things that people are most angsty about, certainly things like Facebook and all the ways in which it's being blamed for its actions, they all relate to the publication of third-party content. And so from my perspective, this is actually the easier question, though I think some people have tried to debate it. So I'm starting with this premise that we're talking about the service's editorial decisions and then providing transparency about that. And if I've lost you now, I'm so sorry. As I said, I'll have more in the paper, but this is really, I think, gets to the central piece of the problem. And then I'm going to explain how the Constitution limits evidentiary discovery into editorial operations. And if you think about the paradigmatic example of a newsroom with journalists and then some government officials coming in and gathering information out of that newsroom, I think the analogy starts to become clear. Those are the kinds of things that we actually are nervous about. If there are limits on the ability to engage in discovery of editorial operations, then there's a difficulty in trying to prove or validate the disclosures that the internet services make in their mandated disclosures. So if you kind of work backwards, you say, okay, tell me what you want disclosed. Now, how are we going to validate that? How are we going to double check that? If we can't answer that question satisfactorily, we've got a really structural problem. If we can't double check the disclosures, then we should assume that anything that the companies are telling us is not credible. It's propaganda, it's fictional, it's just error ridden. If there's no accountability for the disclosures, then the disclosures have no reason to be truthful, or we shouldn't assume otherwise. And if anything, actually, mandatory disclosures create problems for us because we think they are credible, and if they're not, actually the government is producing information that's going to end up being harmful to us. And so if we can't validate the information transparency reports, if the transparency reports or disclosures are therefore not credible and they're actually potentially harmful, this seems like a dead end from a policy standpoint. We're going down the wrong road. And the whole point of going down this road was to get around the partisan gridlock that is paralyzing people who want different things from the internet services. They can't be all things to all people. They can't simultaneously both publish more content and remove or stop publishing more content. And we go right back into that gridlock problem. And I think that's where we may be today. And so I'm going to make my case in a more detailed way about how I reach this conclusion. Okay, so let me talk about the constitutional limits on discovery into editorial operations. And I'm going to give you a couple of cases that I think illustrate some of the limits. Let me first call your attention to a case from 1979 from the Supreme Court, Herbert versus Landau. My perspective is most people have forgotten about this case. It's just like been lost to history and practice. And the case involved a defamation claim against a publisher, a newspaper, editorial publisher, that the content was allegedly defamatory, and the plaintiff says, I want to show that it was published with actual malice. That's really important, of course, because actual malice is required in certain circumstances in order to have a tenable defamation claim. And so in order to establish the actual malice, the plaintiff said, I need to know what was going on in the mind of the editor at the time they were making decisions to publish content in the form in which it was published, so that can show that actually they should have thought about this question differently, or they knew facts that they didn't disclose that would have led them to present it differently if they were being truthful. And the Supreme Court said that if we're going to have an actual malice standard, that plaintiffs need the right to do discovery about what's going on in the minds of editors, so that actual malice can be proven or disproven. However, the Supreme Court went further, and I'm going to just quote the language. Sorry for reading a big block here. The Supreme Court said, there's no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end such as the public interest. And if there were, it would not survive constitutional scrutiny as the First Amendment is presently constructed. So the court's saying, if you are in a situation where you're alleging someone was untruthful and you're showing that that caused you the requisite harm, and in order for you to succeed in your claim, you need to show the mental state of the person who was speaking at the time, then you get a green light. But if you're just looking for problems, you think there's a problem and you want to try and find it, that sounds like the kind of thing that would be disclosures to satisfy curiosity or serve some general end like the public interest. And so go back and take a look at things like the Florida and Texas law. That's pretty much exactly what they're doing. They're saying, we don't have evidence of problems. We want to find evidence of problems. You must tell us about your editorial operations so we can then subject it to further scrutiny. That seems to be exactly what the Herbert versus Landau case said you couldn't do. Now, let me give you a second case example here. The Washington Post versus McManus case. This is from the Fourth Circuit in 2019. And so at issue there were Maryland law that had two requirements. It required online platforms to, one, publish information about political ad buyers. So give some detail about who's buying political ads. And then two, to collect records about political advertising that the service or the platform accepted, and to allow a government agency to come and inspect those records. This did not go well at all. The court's response was that the law is a, quote, compendium of traditional First Amendment infirmities. Now, a lot of the court's opinion focuses on the political ad aspect here, that political speech gets extra protection under the Constitution, and this law was going straight up the teeth of these concerns about protecting political speech. But that's not all it said. And I want to call your attention in particular to the inspection provision. The court says the inspection provision, again, apologies for the long block quote here, brings the state into an unhealthy entanglement with news outlets. The specter of a broad inspection authority coupled with an expanded disclosure obligation can chill speech and is a form of state power the Supreme Court will not countenance. And I think this aspect about this unhealthy entanglement really gets at the heart of the matter here, that in order for us to do things like evaluate the accuracy of mandated disclosures about editorial operations, we need to know how those editorial operations actually operate. We need to gather information about what they're doing, what they saw, what they chose to discard or reject, And if you think about this in the context of rooting around in editorial operations, both we don't want the government to be able to have that kind of insights because of the fact that they may find things that they really are not entitled to receive, but also the overall chilling effect of the monitoring process. It discourages certain types of behavior that are constitutionally protected. And so go back to the enforcement of the Texas and Florida laws. They create the same unhealthy entanglement that I think was at issue in the Washington Post versus McManus case. And in particular, if you go back to like the Texas requirement for transparency reports, statistics about how many posts were kept up and how many posts were removed, and whether or not there was any distinctions among different types of categories of content. In order to really evaluate the accuracy of that, you're going to have to see the whole data set. You're going to have to do your own independent analysis of that data set. And you're going to have to second guess the editorial judgment, say, I see the service counted this particular item of content in category A. I think it should have been counted in category B, and that's the basis on which their transparency reports were inaccurate. And it's exactly that kind of second guessing of the editorial decision making, the kind of saying, I need to see everything you say, and then I'm going to apply my own independent filter. I think that's exactly what the Washington Post case is saying you really can't do. Let me make two general observations here that I know are on your mind, because I know you're already chomping at the bit to tear into me. So let me make this general observation. Observation number one is that I think it's this entanglement with speech, the chilling effect of First Amendment protected activity from the scrutinization that distinguishes the mandatory transparency about editorial operations from other forms of mandatory disclosures that we have in our society. We have them all over the place. They relate to goods and services of all different types, and many of those are constitutional. That's fine, and I'm not taking issue with those disclosures. I'm saying there's something special and unique about the editorial operations question, and trying to provide greater scrutiny into that distinguishes these particular questions from the legitimacy of nutrition facts or of disclosures about the sourcing of the national origin of goods or services. Those are just different, and I think they're qualitatively differently. And so one of the pushbacks I immediately get is, why isn't this just like nutrition facts? Answer, because we're dealing with not a can of corn, we're dealing with how editorial operations function and the chilling effects that might occur from changing their behavior. Second observation is then the standard question is, okay, so fine, get rid of the Florida and Texas laws, but we should be able to have just general standard consumer protection enforcement. We should be able to bring in consumer protection laws that say, if you say something on your site and you break your promise, we should hold you accountable. Or UDAP is unfair and deceptive acts or practices. These are standard types of consumer protection laws. State AGs enforce these every day. And I think that the point is that whether we require the disclosures in specificity or more generally through these consumer protection laws, I don't think they change the underlying question. How are we going to validate the information that's being disclosed? And if we can't get the evidence to validate that without running into the constitutional problem, then calling it consumer protection or calling it social media platform specific regulation doesn't change any of the underlying questions. Let me give you a case study of a case that I'm watching. You're probably not paying attention to it, but I really think that this is a cautionary tale to all of us, frankly, about what we think we're doing to try and embrace digital due process, and isn't that going to lead to great outcomes, is actually going to be a tool for potentially very pernicious types of enforcement. Let me talk about the case involving Twitter versus Paxton. Some of you may be familiar with Paxton. He's the Texas AG. He's also a very controversial figure. He's got plenty of legal entanglements of his own. And what happened is that when Twitter deplatformed Trump, and I'm sorry to use the term deplatform, but when they terminated his account, kicked him off their service, he opened up an investigation into Twitter. Basically, I'm going to fight for my president and challenge Twitter's decision to remove him. So he invoked standard consumer protection laws. HB 20 wasn't on the books yet, although he certainly would have used it if it had been a tool available to him. So he goes on standard consumer protection laws and he issues a CID, basically a demand for additional information. And the CID includes, among other problematic demands, it says he wants to see all policies and procedures related to content moderation on your platform, including any policies or procedures that limit the reach or visibility of content intended for public viewers. And so let's just stop right there and ask the question, what information that Twitter generates in the course of its editorial operations of deciding how to manage its content moderation operations, what information is not included by this particular demand? What information is not available for the Texas AG to scrutinize? And if the answer is everything is included, well, we've got a bunch of problems there. We've got the problem, of course, that's overbroad in ways that we should object to. We got the problem that this is the C part of it is continuing. It's an ongoing obligation. So this is not only applying to the past, but to every decision that Twitter currently makes, also now is so as to be CC'd over to the Texas AG. And then we've got this unhealthy entanglements problem. We've got the fact that what's going on is that basically Paxson saying, I want to be able to scrutinize every aspect of your editorial operations. You're under surveillance, and as a result, potentially changing the way that Twitter will make the decisions. They know they would rather get rid of AG Paxson supervising their work. The way they would do that is to give him what he wants, like re-platform Trump. If they did that, that would be exactly the kind of thing that would say, okay, now that you've done the thing I want, I'm now satisfied. Which is exactly the kind of lack of editorial discretion that the First Amendment precludes. Now, Twitter's response, and again, I'm sorry for the block quote, quote, anytime a Twitter employee thinks about writing something related to content moderation, the employee knows that AG Paxson has already demanded production of whatever the employee chooses to write. That would lead a person of ordinary firmness to think twice about what to write or what editorial decisions to make or document. Remember, one of the benefits of transparency is that it is what gets measured gets done. But that now works in reverse in this circumstance. If that's what's getting measured, then it's going to change what gets done in a way that now is an incursion on the First Amendment. What's really unfortunate about this case is Twitter has been unable to shake the CID that AG Paxson issued it. It's just sitting there. Twitter went to court to say the court, get rid of that CID. The court said no, until Paxton brings some obligation to compel conformance with the subpoena, it can just sit there. It can just be floating in the ether. And so Paxton has opened up this never-ending obligation on Twitter that Twitter, I think, is disregarding. It's every day accumulating additional legal violations by ignoring this, and hoping that if there ever is a court battle that Paxton initiates, at that point they can bring in all their defenses. But right now, we're just in a standoff. Twitter can't do a damn thing, and Paxton's more than happy to just let this sit and keep stressing Twitter. Okay, just a reminder, I said if we can't get the information or to validate the disclosures, I would take the position that the results that we get then are not likely to be credible. Why would that be the case? Some obvious things. If you're not going to be obligated to validate the accuracy of your information, you're not going to invest in it as much as you might otherwise. There's going to be judgment calls that you're going to make. You won't know how to characterize as a service. You won't know what to do. So you can make the judgment calls that are in your best interest as a service. There's certainly concerns about services revealing their trade secrets or enabling gamers to be able to game their efforts to suppress them. And so they're not going to want to be forthcoming in disclosures to the extent they think that might reveal trade secrets or enable the gamers. And certainly they're not going to want to be truthful if they were going to be admitting some legal violation. So if the disclosure would cause them to make an admission, they're not going to want to do that. And even if it isn't a legal admission, they're not going to want to make disclosures that conflict with their public narrative. So it's quite common for internet services to say things like, we're really tough on this category of content. And if the data would show otherwise, what they would want to do is potentially massage the data so that they can keep their public narrative consistent. And so these are all reasons why if they're not enforceable, what we're getting from the internet services is not likely to be credible. I should warn you, again, another reason why you may not like this talk, this problem exists even with voluntary disclosures. If we can't enforce them, even though they're voluntary, we have the exact same problem. All right, I hate to raise problems without solutions. I'm going to raise a few solutions. I'm not super satisfied with them. You're not going to like them either. So some of the solutions might be, the most obvious one is say, okay, if the state or a private plaintiff can't go in and root around in the editorial operations of internet services, what about if we require them to do third-party audits? So let's go get a third party to come and tell us the snapshot of what's going on with the editorial operations, rather than forcing the internet service to reveal them as self-reported information. And this solves a number of problems. This certainly, I think, would address the deliberate falsity problem. That third-party auditor is probably not going to be as amenable to putting their reputation and potential legal risk on the line. However, it doesn't really solve the entanglements problem. In order for us to then now double check the third-party auditor statements, we have to get the exact same evidence that wasn't available from the self-reporting. It doesn't really solve the problem. And of course, it could be quite expensive, and this might become its own chilling effect by driving people out of the industry. We can do things like require some kind of mandatory governance procedures. I think about something like designating a chief transparency officer who has legal duties under that if they hold that title. Just like there are legal duties associated with being a chief financial officer. There's certain things that the chief financial officer must do to hold that title. In the paper, I'll talk briefly. I don't really think that this solves any problem. I can't really figure out how to make this work, but I want to put it on the table for discussion. And then the third approach, and this is the one that you might actually like, and I certainly know that this has been a subject of conversation among your group, is that independent researchers could definitely hold internet services accountable for their disclosures in a way that the internet services might not prefer. And this might be a way of accomplishing transparency that would be better than the self-reported information, because independent researchers will have less reason to try to massage the numbers to try and protect their self-interest. So I love the idea of independent researchers. As we know, if internet services voluntarily provide data to the independent researchers, there's already the risk that they're skewing the data sets that the independent researchers can see. That accusation has been lobbed against Facebook at minimum. And so the best thing would be if the independent researchers could actually get the data themselves rather than relying upon the internet services to provide it. And that would require us to do things like providing some kind of liberalization for data scraping. Now that part we might all agree upon. And so if you want to talk about that, we'll find our win there. Okay, so let me just recap for a moment. I've raised the concerns about how we would validate any mandatory disclosures because of the constitutional limits. If we can't validate them, then we can't consider them credible. Ways that we can work around it, I feel, might not be all that satisfactory. And so as a result, I asked the question, are we at a policy dead end with respect to mandatory transparency? I'm not sure where I am on time, but I'm going to take my break here. I'm going to stop my share, and I'm going to turn it over for comments and questions.
Great, thank you so much, and don't be so self-deprecating. This is a powerful argument, you know, that the fact that I and others might go after you on this is not. You may actually have the better of the argument, but let me try my best on some of this. There's a threshold question here as to whether Facebook is the Washington Post, right? And so that is, you know, if their judgments on content moderation are the same as what is being published in the Washington Post, and of course you're right in all of this. But do you really want to go that far? Do you really want to say that it's, for First Amendment purposes, that it's perfectly analogous? Because does everything hinge on that analogy?
Okay, yeah, I absolutely do intend to go exactly that far, and it's because I cannot distinguish the publication function that internet services provide compared to the offline publishers. They do the same basic thing. They gather, organize, and distribute content. To me, that's publication. Now, they might use different methodologies for gathering, organizing, and distributing content. So the methodologies might differ, but the functions are the same. And the results, in my opinion, are the same. They're publishing third-party content using their own editorial standards. And I think we would all agree that the internet services have their own editorial standards. They might not always apply them prospectively. They might sometimes apply them retrospectively, but they have their own list of standards. And Facebook, as you know, has hundreds of content rules. Those are the same kinds of editorial standards that you would expect to find in any publisher.
Well, but part of the question, and this does merge a little bit with both the antitrust discussion and the CDA 230 kind of discussion, which is there a point at which YouTube, because of the monopoly position of these large platforms, that we should think of them for First Amendment purposes a little bit differently than we would, newspapers, which are, much more ubiquitous.
So to be clear, the definitions of social media platforms differ by statute, but many of them reach people that we would say are not dominant market players. And
I'm with you there.
Okay,
I want to let's just focus on Facebook and Google and Twitter will include Twitter in this too.
Okay, but just to be clear, right? So the Texas and Florida laws might be constitutionally infirm on that basis, even if the goal was to try to reach these dominant market players. And I'm sorry to bring up kind of a tired cliche, but literally this issue was addressed in the mid-1970s in the Miami Herald versus Tornillo case. And just to remind folks, that case involved a Florida law that required newspapers to publish a right of reply, or to give a right of reply. So if they went after certain political candidates, then those candidates would have a right to respond in the same pages. And the first part of and the court struck down that law and said that violates the First Amendment. You can't tell newspapers what they must publish. That's a very obvious offense on the First Amendment. But the court, in the first part of the opinion, talks about the fact that local newspapers at that time in the mid-1970s were dominant market players in their local markets. And there was a lot of discussion in the litigation history of that case about the fact that the newspapers were monopolists in their local markets. And the court said that didn't change the First Amendment analysis whatsoever. Now, again, if you're still stuck in the idea, but that might have applied to the Washington Post, but we're talking about some other kind of entity, I'm still not going to be able to bring you over on that. But I don't think it changes my analysis at all about the fact that we might be talking about someone who has a dominant market position, if that's even true, because that was true in the 1970s with local newspapers, and the court said, so what?
Let me move to, I think, an analogous argument dealing with CDA 230. Would it be your view then that so suppose we had transparency, as has been proposed, that we have transparency requirements that CDA 230 immunity is conditioned on performing certain types of transparency obligations? What about something like that? Because, once you start talking about them so much as publishers here, right, then it seems to, invite that debate, right? So that if we said, look, you want the First Amendment rights to basically be like the Washington Post, then fine. You're going to lose your immunity under CDA 230. Or we could say that, all right, if you want to be a big, and let's say we limit this to the largest corporations, because I agree with you on the small ones, right? But so that if we say someone, a firm that has over 50 million monthly active users, if it wants to continue to get the immunity under CDA 230, it has to say what it's, basically what it's doing when it comes from the standpoint of content moderation.
Okay, so there's actually like 3 or 4 questions baked in there. Yeah. Let me kind of pull them all apart for a moment. So let's start with the basics. Section 230 is an exceptions law. It says that the exact same defendant publishing the exact same content that harms the exact same plaintiff might have different legal outcomes depending on the medium. If they publish in Dead Trees, no Section 230. Publish it in electronic form only, Section 230 applies, potentially no liability where there would have been liability in the Dead Tree. Same exact plaintiff, defendant claims and content at issue. The medium makes a difference. Certainly there's a lot of people who question that model. Like, why would that be the case? We should not be privileging one over the other. I do want to point out, I am a supporter of Section 230 and the exceptionalist consequences that it has, because there's a bunch of things that we get because of Section 230 that we never saw in the offline world. And so mucking around with Section 230 potentially puts in jeopardy those benefits that we get that we've never saw elsewhere. But that's a social policy, and one that I'd be happy to explore further. So now you said, okay, we're not talking about eliminating Section 230, we're talking about conditioning it on making these disclosures. And I think that those kinds of approaches on Section 230, saying you only get Section 230 if you do X, Y, or Z, create their own constitutional problem. Basically, you can't condition a legal privilege on things that would otherwise violate the First Amendment. So if the transparency obligations violate the First Amendment, conditioning the Section 230 privilege on it is its own violation. And believe it or not, the cases in this area are from the trademark registration context, where the trademark office gives a privilege, the trademark registration, but there were conditions on those privileges that it couldn't involve certain things that were basically First Amendment protected content. And the court said, you can't do that. You can't establish that linkage. So I don't think that conditioning Section 230 on mandatory disclosures works around the constitutional problem. And in a sense, it creates a different constitutional problem. And then the last thing I'll mention is that making size-based distinctions regarding Section 230 creates, I think, two additional problems. One, it's actually really hard to draft good size-based distinctions. And I have another paper with Just Myers, where we actually tried to talk about all the difficulties that none of the legislatures have read this. So the ways they're drafting those provisions are just terrible right now. There's really a need to up-level that conversation. But even if you got past that and drafted one properly, following some of the guidance we offer, then you have another constitutional problem with saying, why do we make the distinction between X and Y? How do we decide that these particular entities are required to do this behavior and other entities who are in the exact same functions, exact same industry aren't? And I think that it would be very difficult for a legislature to defend where it drew the line in these size-based distinctions. So that might create yet a different constitutional problem. So I'm sorry for such a long-winded answer to your question, but you have like 3 or 4 of them in there, and each of them deserves to be pulled apart.
But ultimately, it does depend on, and I'm not just, well, I do disagree with this, but I'm not, I'm just sort of trying to crystallize the disagreement, which is that if you believe that basically Facebook is just another website, let alone one that's just like the Washington Post, then a lot of this follows from that. And so then as you know, there's all of this scholarship now about trying to say that they're common carriers, right? Trying to say that they're places of public accommodation. All of that has to be taken off the table, right? I mean, that none of that could be right for your argument to work, right?
Yeah, I don't know what the transparency obligations could look like if something was a common carrier or utility, but the basic First Amendment objection that I have would go away because at this point now there's much greater room to make incursions onto their freedom of speech in the first instance. And so every time you hear people talk about common carriers or utilities, what they're really saying is we want to strip these entities of their constitutional protections and then give the government a much greater range to regulate them. And don't think that the regulations will just be the ones that you like. They're almost certainly going to be the ones that you're going to say, oh no, I sure hope the government can't do that. And that's, I think, part of what we're seeing with the Florida and Texas laws, that what they did included things that I'm sure some of the people who are watching this video thought were great. And there were probably some things where you're like, no, you really shouldn't be doing that. And if the First Amendment doesn't apply because they're a common carrier or utility, or the First Amendment protection is lesser, all of those are now on the table, not just the things that you want.
Someone, Allison Hayward in the Q&A asked the question about, well, hey, if this is unconstitutional, how could it be that campaign finance disclosures are constitutional? Because that's cutting right to the bone of speech, right? And you're literally regulating even individuals, and you're forcing them to reveal how much money they're contributing and sometimes even spending. So is there a tension between, say, your view about the effect of transparency on the First Amendment rights of large corporations versus the kind of transparency that we have in the campaign finance context?
Yeah, thank you. It's a really excellent question. The Washington Post versus the McManus case dealt with this directly, and it said we're not going to opine upon the legitimacy of obligating the ad buyers to make disclosures, but shifting that to now this intermediary creates problems with the intermediary's own First Amendment protected decision making. So in a sense, that question lumps together both the original speaker and then the intermediate publisher. And the court said you have to disaggregate the two and treat them differently.
Looking over some of the other questions here. Well, let me spin one of these in a little bit of a different way. So part of when I was testifying in the Senate, I guess a week or two ago, right? Senator Johnson went off on the ideological bias of the platforms, right? And it's similar in his questioning and the motivation that behind both the Florida and the Texas law. And so he comes out and he says the platforms in their content moderation policies are biased against conservatives. The platforms, of course, reject that characterization. Are you saying the government cannot, if they are lying, right, and they are basically censoring conservatives, that there's basically nothing from an anti-fraud standpoint that the government can do to try to hold them to that, to basically to validate that whether they are lying or not?
So this paper doesn't directly tackle that issue, but yes, I would say that. And I'm just going to say a few more words about it. When we talk about bias in editorial decision-making, that's unavoidable. The whole process of publishing by nature privileges certain content over others. And we accept that most publishers have a bias that's beyond just their bias towards better content over worse content, that there's some slant that they've adopted. And that slant reflects the fact that they're catering to their audience, and their audience's idiosyncratic needs are going to require them to screen out certain content and prioritize or privilege other types of content. And so even if it were true that the major internet services had a political bias, which it really has not been proven, the empirical evidence in support of that is shoddy at best, and usually it's quite embarrassing to invoke it. Even if it were true, what another way of saying that is saying they've chosen to cater to their particular audience, and they're serving the needs of their particular audience, which they are free to do, and in fact, their audience expects them to do.
But the question is whether they can lie about it, right? Whether they can lie about what they're doing, and if the government has any recourse in order to address those lies, right? Because that's what transparency is trying to achieve, is to try to say, all right, we don't trust the firms simply to report this. There's going to be some sanction if they misrepresent what's actually happening. And in the same way that we talked about and you mentioned this, like the goods and services situation, like with financial disclosures.
So we've got a threshold question. Where do they make a promise that they're now no longer keeping? And so I'm not clear where they've made that promise.
Just say it's in the content moderation. So this could apply not just to the political bias issue, but just to their articulated content moderation standards too. This is what violated on our platform. This is what we are doing, right? Now, I took you to say before that the fraud, that you basically cannot police fraud. That is not the kind of fraud that could be policed consistent with the First Amendment. And that is your argument, right?
Well, I'm sorry. Now you put a bunch of words in my mouth, and I'm not sure.
No. I'm sorry. I'm not trying to be unfair. I really just trying to isolate. If one of the things that transparency is trying to do is to, just to reveal what's happening under the hood with respect to content moderation, you make a powerful argument to say that, look, we would never allow that to happen, and we go in and monitor the editorial judgments of the Washington Post. And so, and my question is, all right, so that means, doesn't it, that the, if they proclaim they are doing X when it comes to content moderation, but they're actually doing Y, right? That there's no way that the government can can essentially police those promises without violating the First Amendment.
Yes, I think that's right. But I think I want to make sure that we're, the reason why I was asking where this promise was made is because, in fact, I'm not sure how often the internet services actually promise about what they're doing or not doing in a way that they it could be legally obligated at all. So, for example, if their terms of service say, here's what kind of content we're looking for, they're not liable if other types of activity takes place. That's pretty clear. So we're almost like trying to say there's some other place that they're making a market representation, saying this is the kind of stuff that we want. And then they're actually saying, we really don't want that. And we're not going to tell the public we don't really want it. This issue comes up, actually, the most common places this is going to come up is with some of the conservative leaning apps that keep saying as part of their market representation, we won't edit your content, we want all views, and then in fact they can't enforce that. So I think those are a better test case than perhaps the Facebook example that might be on people's minds. But just to go back for a moment, I think about the New York Times, all the news that's fit to print. We know that's not true. We know that there's some editorial bias that is baked into that. We might consider that from an advertising standpoint to be puffery, not a promise. And that's, again, the problem I'm having. How would you distinguish the New York Times saying all the news is fit to print from whatever the example is of the statement that you're trying to prove is not true? What's the difference between that? But finally, the last thing I want to say is when it comes to this political bias question, the only way we could answer that is by looking at pretty much everything. We can't do these cherry-picked anecdotes. That doesn't solve the problem at all. And that's exactly the kind of thing I think we should be very nervous about, that any kind of government regulator can demand to say, I want to see the entire data set, or any private plaintiff gets to say, I get to see everything and get my experts to go trolling for problems. I think that we should be really nervous about what that would look like and what kind of potential risks that might pose to us.
Well, let's be clear about who's the risk toward. And so, as I understand, the argument is that this is the First Amendment rights of the corporations, right? This is not the First Amendment rights of the speaker, the users on the platform. Is that right?
I'm sorry, you said the corporation. I'm going to talk about it as the publishers. That this.
Facebook. I'm not trying to.
Okay, fine. So like just a reminder, right? The First Amendment says that the Congress cannot restrict the freedom of speech and the freedom of the press. So whether you get there under speech or press, we've always contemplated that publishers get special heightened protections under the First Amendment.
No, but by that I mean, look, I could see you even expanding the argument to say that it's not just the First Amendment rights of Facebook and Google, right? It's the First Amendment rights of the users that are implicated here. But you're sticking with basically the platforms, right?
Yeah, no, I'm just going to talk about I think the First Amendment questions that relate to the users really interesting, but I want to get rid of the state action question because that then would throw a kink in everything. As you know, many plaintiffs have tried to argue that the internet services are government-like enough that they should be obligated to honor the First Amendment, and that's definitely not an argument make. It's one I'm fighting against actively. So our mutual friend Daphne Keller has a question, which is, since you both were testifying in the California Senate today, but she missed a little bit of the Washington Post versus McManus discussion, but she asks, does this what about sort of content neutral versus content-based disclosure obligations? Is that a way of distinguishing between different types of proposals, so that if you're just saying, look, reveal what you are doing, right, as opposed to something about a particular, the way she asked it, right, given that the analysis of McManus turned on the content-based nature of the speech at issue, how much of a barrier does it present to content-neutral disclosure obligations? Yeah, and because of that provision I mentioned about the court slicing down of the inspection obligation, that wasn't really content-based. It was really just, you can't force the collection and exposure to a government agency of this third-party content. I feel like trying to bring in these constitutional notions about content-based versus content-neutral doesn't really address any of the concerns that I have. But we also know, just to be clear, and I do want to make this point in the paper pretty clearly, there's definitely other kinds of disclosures that don't relate to editorial operations that are fair game for the government. I'm not saying that online publishers can't be obligated to file tax returns or something like that. If it doesn't relate to the editorial operations, then it's outside the scope of my paper. But looking into the editorial operations, whether content-based or content neutral, I think is equally problematic from my perspective.
So one anonymous questioner asks about the ads, political ads libraries, for example, right? And so Twitter, Facebook, Google have developed these political ads libraries. So do you think when it comes to advertising that mandating that kind of transparency would also be illegal, unconstitutional?
Yeah, that was pretty much what was at issue in the McManus case. It was basically the inspection requirement was basically libraries of political ads. And that's just a no-go. I'm glad that the internet services are offering up their own libraries of political ads, but as we know, we might question whether or not they're drawing the lines the way we would. And that gets back to the independent researcher piece. If we're relying upon their libraries as they've curated it, we might not be seeing the whole picture.
But this goes back again to Allison Hayward's question, which is that is there, I mean, how is it that we could basically we could force Facebook to disclose the amount of money it spends related to political campaigns, but we can't force it to disclose the amount of money that is being spent on its platform with respect to political advertising, candidate-based endorsements and things like that.
I love that question. That's like a really great question, isn't it? Because it really gets at the heart of the matter. When Facebook is spending its money on political influencing, lobbying, they're acting in a functionally different capacity than when they are publishing third-party ads. And so the reason why we might make a distinction is because there are just legally different roles that they're playing in the overall ecosystem.
But why is it? But part of the question is, what First Amendment rights does Facebook have to object to neutral disclosure regulations for that are campaign finance related, right? So that if you can regulate the company in its speech with respect to its spending, right, and you can regulate the individuals who are spending money on Facebook, why can't you force Facebook to then also reveal just how much money is being spent? I just don't. I mean, we can say that, all right, well, there's a kind of curatorial aspect to this and all of that, but ultimately there's going to be some kind of balancing here, between the whether it's fighting corruption or other kinds of, say, reasons to deal with campaign finance. Why wouldn't that apply, to at least on the other side of the balance when you're weighing their First Amendment rights?
So, definitely, I think the McManus case is worth the read on this point because the court really did see them as two different questions. And I come back to the idea that we're going to, because the person who's engaged in the behavior is playing different roles in the ecosystem, one set of rules are going to be chilled in a different way than the other set of rules. And so the disclosure obligations might chill the campaign lobbying, but we might accept that as a cost of getting the right to participate in our political process. Whereas forcing the publisher to make disclosures might chill that entire category of activity. And we might decide we don't want to chill the entire category activity. And always we can put the burden on whoever's buying the political advertising. That's going to be a separate First Amendment question, but that's not at all at issue in the points I'm trying to make.
Mark Lemley asks, could the government require Facebook to allow interoperability and or data scraping? Would that facilitate transparency? Obviously, you had data scraping toward the end there, but wouldn't that also raise First Amendment concerns?
Sorry, I just want to take a note about the question. Maybe, it raises just a bunch of other questions that I wasn't ready to get into. I think data scraping really requires its own set of analyses about it. The data scraping is different from, say, a mandatory production of information, because it might be the difference between something like compelling speech and permitting people to gather their own information. But we might say, for example, mandatory data scraping constitutes a takings because we're now forcing people to spend money on their personal property that they can enjoy the full benefit of. So to me, we might shift the locus of the problems into different things. I don't want to get into that in my paper, certainly. I'd love to have that conversation separately because I think there's some really interesting questions. In terms of interoperability, I think that this is one of those questions that I don't know has been fully explored. So for example, it's quite common for privacy laws to have data portability requirements. So there are already laws on the books that require companies, including internet services, to allow users to gather information and then take it somewhere else. Because those come into the privacy rubric, we tend not to think about the First Amendment concerns about those. It might very well be different if it is a company, say, that manufacturers steal, and what the data portability they offer to whoever information they're required to provide from a publisher who might have a different set of requirements. And at least here in California, the privacy law actually excludes publishers from some of the obligations to avoid any potential risk of a First Amendment entanglement. So I think there's some really interesting questions that need to be vetted there. And I hadn't planned to get into this paper, but I think that they're certainly, I don't think they've been resolved. I think they're still live.
Well, but part of the what I think Mark is gesturing toward is whether if we start thinking about them real, or maybe not started, if we think that Facebook is the Washington Post, are there neutral kinds of regulations, right, that now start seeming suspect because it looks like the government is embedding itself inside a publisher, right? And so even some of these privacy laws, right, like the neutral private, I mean, you're sort of just talking about that, right, start seeming a little bit problematic. I think, like, can we even prevent them from getting information about their user population, right? So that some kinds of prohibitions on micro-targeting, right, or prohibitions on gathering data and the like. Would those trigger First Amendment problems, do you think?
Yeah, they might. And I just want to remind you, I kept on using this magic phrase that I haven't defined, and I'm not even sure I defined my paper, or maybe I need to. I'm really focusing on these editorial operations questions, the editorial decision-making process. I think that once we understand the boundaries of what's permissible with that, then we might also start looking at adjacent activities and saying, how far does that go? Maybe to Mark's question, the question might be, could the government require this interoperability where internet services are required to provide a feed of all the third-party content that they've gathered, organized, and disseminated on their network? Could they be forced to also make that available to all comers? And I think when we say it that way, we might ask some questions about the First Amendment aspects of that. We probably would have some reservations about the policy consequence of that. But to me, that's a different question than how we actually scrutinize the editorial operations, the decisions that they had in the first place about what information to gather, organize, and disseminate. So I'm not trying to dodge the question, but certainly for this paper, that wasn't where I wanted to go, because I am trying to set up a perimeter around these questions on editorial operations.
Great. Well, I think we have now run out of time. David, do you have the slide for next week? So next week, we've got Dean Freeland from the University of North Carolina at Chapel Hill. His talk will be moderated by Jeff Hancock. I'm told from the chat right now that it's on analyzing social media from a user eye view with pie graph. So I'm not sure what that means, but it sounds artistic. But Eric, thank you. This was absolutely wonderful. I have to say, obviously I'm a very pro-transparency kind of guy and have been trying to push legislation in this area. But the First Amendment issues that you raise are real ones, and they're really, really challenging. In fact, I'm going to put in the chat for those who are interested. I've written a piece on basically the constitutional status of large social media platforms, where I show my skepticism here, but I think I'm arguing uphill, and I think that Eric made a powerful argument today about why they should be considered publishers. So thank you so much. Hope to see you live once we start doing these live again, since we are neighbors. So thanks so much, and thanks everybody for joining us.